The company formerly known as MultiPlan and now as Clarative claims to be a technology, data, and insights company focused on making healthcare transparent, affordable, and fair for all. Multiple plaintiffs in federal court litigation against MultiPlan and multiple of its insurance company clients, including United Healthcare, Cigna, and Aetna, claim that it's anything but. The plaintiffs, a collection of medical groups, hospitals, and other healthcare providers, allege that MultiPlan and the insurers conspire to suppress out-of-network reimbursement rates by jointly relying on a third-party algorithm, MultiPlan's pricing tool, to set reimbursement benchmarks and influence pricing strategies. The U.S. Department of Justice has now weighed in, filing a statement of interest, a brief, in the case. Here's the DOJ's position in plain English. You don't need a secret room and a special handshake to violate the Sherman Act prohibiting price fixing if competitors jointly rely on the same pricing tool to coordinate how they set their benchmarks, even if they input different data or tinker around the edges. It can still amount to concerted action. In antitrust speak, that's a combination or conspiracy in restraint of trade. In normal speak, it's a price-fixing allegation with a modern twist. The DOJ's point is this: agreeing on a starting point for pricing, even if you end up somewhere else, still rigs the race. You don't need to cross the same finish line, just start in the same chute. The insurers argue they never exchange sensitive information with one another, so no harm, no foul. But the DOJ sees exchanging data through a shared algorithm as still exchanging data. If you feed your internal strategies into a black box that your competitors are also using, and that box spits out pricing suggestions with competitive implications, you might as well have emailed your competitors directly. One of the more curious defenses raised in the case is that reimbursement rates to out-of-network providers don't count as prices and thus can't be fixed. But saying that healthcare reimbursement paid by an insurer to a provider isn't a price is like saying a copay isn't cash. Cute, but no. And the DOJ's position is that when insurers directly pay providers for services, they are purchasers in the market, and agreements among competitors to suppress those rates are price fixing in the classic sense. In fact, they are per se unlawful under antitrust law. The DOJ's filing in the MultiPlan case sends a strong signal that the government's position is that algorithmic coordination is not beyond the reach of antitrust law. The form of coordination might be new, but the function, suppressing competition, is familiar. As healthcare payers, tech platforms, and pricing vendors increasingly collaborate through sophisticated analytics, this case is a clear reminder: if you're coordinating decisions that competitors used to make independently, you may be coordinating antitrust liability as well. And note carefully that that concept doesn't simply apply to prices paid by insurers. It also applies to prices charged by providers.